I'd like to reiterate just a few general points about the Supreme Court before we go a whole lot further. The first is just to remind everyone that the court is part of our political system. It's definitely more insulated from politics than most legislators are, and certainly most top members of the executive branch of government. But it's still a wing of our political system, and therefore it's affected by everything else that happens on the political landscape. A lot of Americans tend to forget about this element of the Supreme Court. Second, an awful lot of what the court does in its activity is define and limit what can be done by other entities of government. So, for example, recently there was a ruling about Arizona's state immigration law. The court tossed out several features of that law, but it allowed the state to keep part of the law as well. This redefinition process is arguably what the court has been doing over its many long decades of activity. Now, in the last segment, I talked some about the Steele seizure case, which was a good example of the court being part of the political process. And I talked about how it responded to President Truman's actions in a way that really reflected the views of many voters and members of the political establishment in the early 1950s. We talked a little bit about some Warren Court decisions, particularly the Brown versus Board of Education case. And I also mentioned the Baker v. Carr case about voting rights. I talked about the 1973 Roe decision on abortion. But I didn't mention a prior important case, which was the Griswold case, which claimed that there was a right to privacy in the Constitution that could be applied to marriage. It's hard to believe from the modern perspective, but in the 1960s in Connecticut, there was a law that forbade married couples from purchasing birth control at the local pharmacy. And the court had a challenge that came to it, determining that a rule in the Constitution that would authorize the discontinuation of that policy by the states. And anyway, fascinating ruling. We also mentioned the Miranda ruling and the rights of criminals. I talked some about the Berger era cases, and a couple that I didn't mention were the Swan case from 1971, which allowed school districts to use busing to achieve integration of public schools. And another case of this era, which has gotten some coverage in the news lately, was U.S. versus Nixon, 1974. That was the time when the court ruled that Richard Nixon had to turn over to prosecutors the tapes he had made of his own conversations in the White House during the time of the Watergate affair. And I said that more recent conservative justices of the court have presided over modifications of earlier rulings, but not really radical shifts in the direction set, really starting under the Warren Court. Now, in class, I usually talk about how religion has been treated by the court in recent decades. And here I like to focus on the Lemon case, and then after that, the Lynch case. Both of these were fascinating cases involving religion. Now, in 1971, in the Lemon case, the issue here really involved state funding for private religious schooling in Pennsylvania and Rhode Island, which were the states involved in the case. Some very modest state money flowed mostly to Catholic schools to provide supplementary education services to underprivileged kids. Now, there were some groups that charged that no state funds ought to be used at all in private schools, no matter how poor the kids. And that's what prompted the case to reach the court. Now, the court set up some rules of thumb in its decision for what to do when the public and religious sectors come into contact with one another. First, they said the law must have a secular purpose. In this case, educating poor children, which is very clearly a secular purpose. Second, they said the law shouldn't really advance or restrict religion. And third, they said the result should be that government and religion not be too excessively entangled with one another. Now, this is where the Pennsylvania and Rhode Island laws really ran afoul of this newly articulated policy. It really turned out that there was not a good way to track the money that went through private schools to these poor kids without really entangling the government too much in religious schools. So after this Lemon decision came down, a lot of the supplemental education programs that had been rooted through private schools just either ended or had to be modified quite a bit by the states involved. Now, by the mid 1980s, about 15 years later, the court decided to modify the Lemon rules, and it did so with the Lynch versus Donnelly ruling in 1984. Now, this was the famous Christmas creche case. You'll hear it referred to sometimes as the creche case. So what happened was the city of Pawtucket, Rhode Island, every year had a big Christmas display on the courthouse lawn. And the display included a Christmas tree, Santa's elves, all the lights, a menorah and some other Jewish symbols. But it also included a creche or a Christian manger scene depicting the birth of Jesus in the stable with the animals and wise men and so forth. There are millions of these kinds of things in houses across the country. And a group sued the city alleging that this particular display of the creche amounted to an endorsement of Christianity by the city government. And of course, that would be prohibited by the Constitution's ban on establishment of a religion. So the court ruled in favor of the city and said that as long as the creche was displayed along with other elements of the secular holiday, really the presence of the creche didn't violate the Constitution. And so, in other words, what the ruling said was that there were some constitutionally ordained restrictions on entanglement of religion with government, and the Constitution should be read so as to accommodate religious expression rather than stifle it. And if you track down the ruling and read it, which I encourage you to do sometime, you'll see that it notes a whole host of ways that religious expression is accommodated in American public life, and quite a number of these are listed on this slide. So, for example, we have a National Day of Prayer, we have religious-oriented holidays, we have In God We Trust on money, so forth and so on. Now, what the court did here was refine the rules that had been laid down initially by the Lemon case. And the relevant question to ask of a publicly supported religious expression, said the court in Lynch, was whether it tends to establish a religion or a religious faith. And the court looked at the use of the creche and said, no, this doesn't really amount to establishment of religious faith. Now, if the creche were the only item in the display, that would have been interpreted differently by the Constitution. So here's a nice statement on this slide from the Lynch case. If the presence of the creche in this display violates the Establishment Clause, then a host of other forms of taking official note of Christmas and of our religious heritage are equally offensive to the Constitution. Now, in more recent cases that I like to talk about, one more recent case that I like to talk about is one that has really alarmed a lot of conservatives, and that's the Kelo case from Connecticut in 2005. Now, the question here involved eminent domain and the so-called takings clause of the Constitution, which really gives the state the right to annex private property for public use, as long as people are reimbursed at a market rate for the property that they've lost. Now, the main way we normally use eminent domain is in the building of highways. So if the state decides to build a road that goes through your property, then they have the right to demand that you turn over your property for payment to the state. And very often the state then demolishes the property and just uses the land for the road project. Or the state might decide to build a park and decides it needs some adjacent private property. Or maybe they want to build a courthouse or a jail. So you get the picture how the state can oblige you to sell your property if it needs it for public purposes. So anyway, the case here involved the city of New London, Connecticut, which had decided to build a waterfront business park to attract some new industries to a town that had really seen lots of jobs leave in the previous decades. Now, the city worked with a private development company, and the main tenant of the new business area was going to be a $300 million Pfizer pharmaceutical facility, which promised something like, I think it was 1,100 jobs for the city if it was allowed to build this tax-subsidized research and development facility. But 9 of the people who owned some of the property along that waterfront, refused to sell their property. They said, nope, it's ours, we don't want to sell it. And we don't think this is a legitimate use of the eminent domain capacity of state government or city government to take over this property. So the court ended up hearing the case and ended up siding with the city. And the court argued that economic development could in fact be construed as a public purpose and a legitimate use of the takings power of government. Now, the conservatives on the court just blasted this ruling, saying that, okay, if you allow economic development to be considered a rationale for takings, then there really wasn't any area of life that couldn't be subject to some kind of state assault or state involvement. And under this particular understanding of public use, there really wouldn't be any limits. But the court hasn't overruled itself, and the Kelo precedent still stands.